Welcome to today's topic on obscenity charges in digital content under Indian law. As digital content grows, so does the need to understand the legal boundaries around it. We'll explore key laws, recent cases, and available remedies, delivering expert legal solutions with dedication and integrity by ProLegalMinds. The Indian digital ecosystem is expanding rapidly, but with this growth comes increased legal scrutiny, especially around obscenity, indecent representation, and child protection laws. A recent Supreme Court order restraining a popular podcaster over alleged obscenity has spotlighted the strict legal boundaries governing online content in India. In this session, we explore what qualifies as obscenity under Indian law, the relevant acts and legal updates, available remedies, and landmark judicial decisions shaping the digital space today. Let's begin with understanding obscenity under Indian law. While the term isn't precisely defined, its interpretation has evolved through judicial decisions. In the landmark case Avik Sarkar versus State of West Bengal, the Supreme Court held that obscenity should be judged from the standpoint of an average person using contemporary community standards. So the assessment depends on factors like the context and purpose of the content, societal norms, and whether the material is likely to deprave, corrupt, or arouse lustful thoughts. Under the Bharatiya Nyaya Sanhita, 2023, replacing the IPC from July 1st, Section 292 addresses obscene content. It penalizes the sale, distribution, exhibition, or advertisement of any obscene books, images, or media. Obscenity here refers to material that tends to deprave or appeals to prurient interest. Even publishing, sharing, or simply possessing obscene content with the intent to circulate is punishable. This law applies to online platforms like web series, YouTube creators, and podcasters. The punishment? Up to 2 years for a first offense and up to 5 years for repeat violations. For instance, explicit content without age restriction on a streaming platform can lead to charges under this section. Section 67 of the Information Technology Act 2000, amended in 2024, focuses on obscene content in digital spaces. It penalizes anyone who publishes, transmits, or even forwards material that is lascivious or appeals to prurient interest if it tends to corrupt viewers. This section specifically targets digital platforms, like websites, social media, apps, and even messaging services. For a first offense, punishment can be up to 3 years in prison and a fine of 5 lakh. Repeat violations may lead to 5 years imprisonment and a 10 lakh fine. For example, a WhatsApp group admin who knowingly allows explicit content without action can be held liable under this section. The Indecent Representation of Women Prohibition Act 1986 restricts any publication, exhibition, or distribution of content that portrays women in a degrading or indecent manner. Sections 3 and 4 prohibit such representation across print, advertisements, cinema, and now digital platforms. According to Section 2 of C, indecent representation includes any depiction that is likely to corrupt, insult, or injure public morality by objectifying women. The law is clear. First-time offenders can face up to 2 years imprisonment and a fine of $2,000. Repeat violations may lead to 5 years in jail and a $5,000 fine. Though originally framed in a pre-digital age, the Indecent Representation of Women Act now applies to online content through interpretative reading with the IT Act 2000. This means digital ads, social media posts, and influencer campaigns are also subject to scrutiny. For example, using sexually suggestive images of women to sell unrelated products, like cars or watches, can invite legal action under this act. In recent updates, the Ministry of Women and Child Development has proposed amendments to explicitly cover digital media and strengthen penalties. These changes are currently awaiting parliamentary approval as of April 2025. The POCSO Act is a vital legal safeguard for protecting children from sexual exploitation. Section 11 defines sexual harassment broadly. Even gestures, words, or showing objects with ill intent can qualify as offenses. Section 13 targets the use of children for pornographic purposes across any media, including digital platforms. This includes uploading, sharing, or even viewing explicit content involving minors. The penalties are strict, up to 3 years, imprisonment for harassment, and 5 to 7 years of rigorous imprisonment for using a child in pornography, with even harsher terms for aggravated offenses. In the digital age, the misuse of technology for child exploitation is treated with utmost seriousness. Sharing sexualized memes or videos in a WhatsApp group can trigger charges under POCSO Section 13. Even a morphed, sexualized image of a minor posted on Instagram can lead to prosecution under both POCSO Section 11 and Section 67B of the IT Act. The Supreme Court in the Prajwala case directed active monitoring of child abuse content and empowered the CBI to tackle global exploitation networks. In 2024, the court mandated OTT platforms to use AI tools to detect and delete such content within 24 hours. Simply viewing, forwarding, or storing child exploitative content, even privately, is a serious, punishable crime. In Avik Sarkar versus State of West Bengal, the Supreme Court ruled that nudity alone doesn't define obscenity. Context and intent matter. Artistic or socially driven content may not be considered obscene. In Shreya Singhal versus Union of India, while Section 66A of the IT Act was struck down, the court reinforced that obscenity, defamation, and incitement remain punishable. Freedom of speech is not unlimited. In 2024, the Supreme Court instructed OTT platforms, YouTubers, and podcasters to strictly comply with obscenity laws. It also proposed a pre-clearance mechanism to curb mass circulation of explicit content. If someone is charged with obscenity, the first step is to consult a criminal lawyer with expertise in cyber and media law. They may apply for anticipatory bail under Section 438 of the CRPC, now Bharatiya Nyaya Sanhita, especially for charges under BNS Section 292 or IT Act Section 67. The accused can also approach the High Court to quash the FIR under Article 226 if the content is artistic, educational, or not lascivious. Lastly, promptly remove the flagged content and issue a public clarification if necessary to show good faith compliance. To avoid obscenity charges, content creators must adopt preventive practices, implement strict age verification for explicit content, and enable robust parental controls on platforms. Include trigger warnings before sensitive or controversial topics. Ensure all content follows editorial standards aligned with Indian laws, including the BNS, IT Act, and POCSO. For high-risk material, consult legal experts in media and cyber law to vet content before publishing. Proactive compliance protects both creators and audiences. In the evolving digital world, the line between creative freedom and legal responsibility is growing finer. Content creators, publishers, even viewers must now navigate with caution. Laws like the BNS 2023, IT Act 2000, POCSO 2012, and the Indecent Representation of Women Act are actively shaping what's permissible online in India. If you're facing or even anticipating a legal challenge over digital content, don't wait. Consult a qualified legal expert to protect your rights, your work, and your reputation. Empower your legal decisions with expert guidance from ProLegalMinds. Build your journey on a strong legal foundation. Secure your future with confidence. We specialize in FEMA for NRIs and HNIs, family law, real estate law, criminal law, taxation, banking, employment, labor, and immigration matters. Email us at hello@prolegalminds.com. Call us at 949-401-717. Visit prolegalminds.com. ProLegalMinds, law firm for natural justice. Thank you for your attention. At ProLegalMinds, we remain committed to protecting your rights and securing justice for